Hi, I want to talk to you about the differences between a design application for patent and a utility application for patent. A design application for patent protects the ornamental features of a device. For example, if I design this pen myself, and this design I believe it's new and non-obvious over any other pens out there, and I really want to sell this pen the way and it is designed, the way it looks, the appearance of this pen, it's what I'm interested to protect, then I may think about filing a design application for patent so I can protect again the design, the way this pen looks like, and not how this pen functions or the I'm not interested in protecting the structure of this pen. I'm only interested in protecting the design, in other words the appearance of this pen. So in that situation I will file for a design application for patent. But let's say I worked on this pen for a while and I came up with a different way to make this pen work, and I believe this pen works better than any other pen out there. In other words, I came up with the functionality of this pen, the way it writes, the way I can hold it in my hand, or other aspects of this pen are something that I came up with, and I believe they are important and useful and beneficial to users, and I deserve a patent for it. Then I will think about filing a utility application for patent, because I will be interested in protecting the functionality, which of course is related to the structure of this pen, the structural elements of this pen, and that's where the utility application for patent comes in. I want to prevent anybody else from making this pen that will work exactly like my pen. They may make a similar pen that will look different, will look the same, but they will not be able to make a pen that works the same as my pen if I have a utility patent eventually granted by the USPTO. By contrast, again, if I have only a design patent, nobody else could make, use, or sell a pen that will look like mine, even though it may work differently. So even if they come up with a pen that will work differently, if it looks like mine, they cannot do it if I have a design patent, which it's valid and I can enforce. Again, if I have a utility patent, nobody else could make a pen that will work like my pen, even though it looks differently. They can make it look differently, but if it works like mine and I have a utility patent, they cannot do it. So these are the major differences between a design and utility application, and in the end a design patent and a utility patent. There is another difference that you may be interested to know about. A design patent, it's good for 14 years from issue, from the date that the patent issues, and a utility patent is valid and enforceable for 20 years from the filing date of the application or any priority date to which the application claims priority. Of course, if I worked on this pen and I did both. I designed a new look for this pen and I came up with a different functionality or a different structure or both, and I made it also work better than any pen out there, not only looking better but also working better. Then I may be thinking about filing both, a design application for patent and a utility application for patent, so I can obtain both benefits and use both as a tool to protect my invention, eventually keep this monopoly in the marketplace for a while. Thank you for watching.